Hello, everyone. Can you hear me? Awesome, amazing. Well, thank you so much for joining. I am really amazed by the fact that there's 28 people watching this right now. Um, it's um it's really humbling. Thank you so much for trusting in my opinions and for following me on Twitter and here. Um, and well, in general, just for being here. I am 57 now. um, I Look, I want to be clear. I am a lawyer by training and an academic right now. Technology is not really my thing. So if this is like very basic, very like not necessarily the most technological, I apologize. I will probably get better. I hope to keep doing this because I think the main thing that I want to do with this is get international law out of the ivory tower and into that chat box, right? So that you can ask me questions um, and just be informed about the topics that you like and want. Um, and well, I'm really excited. And so I just wanted to start with a few ground rules as to like how this is gonna work. Okay, because we're gonna talk about difficult topics and we're gonna talk about stuff that is like complicated. And just like in my regular classes, things can get difficult. There might be people in the audience that have lived experience that you don't have. There might be people that have gone through things that you haven't, and it is important to keep that in mind. It's important to keep things respectful. It's important to keep things, you know, um, I don't know, nice, I guess. So please be aware that I have been able to find a moderator, and they are authorized to ban anyone who engages in, anti-Semitic or anti-Palestinian or any kind of racism or anything like that. Please don't do that. I'm not here for that. Um, so. Um, let's just focus on the law and what we are what we are here for, which is understanding what the hell happened in the ICJ. um I have prepared a few questions from the Twitter thread um that you answered to. um but feel free to ask me questions over there in the chat room, and I will try to answer them as best as I can. As you probably know, if you follow me, I am a lecturer. I specialize in international um, humanitarian law and the history of international law. I work a lot with the concept of a state. What is a state? Um, how does it get to the thing that we now call a state? And I am also Peruvian, so both of these things will influence how I approach the topic of Israel-Palestine. That's how I approach it in general. I approach it as someone who works with post-colonial approaches to international law, how states become states, what does it mean to be a state, and in general, um, the law of war, the history of international law, and this is a conflict that is at the heart of this all. Like, I don't think anyone can work in international law without, you know, knowing about this topic. Um, so yeah, okay. With that being said, I will try to keep this as interactive as possible. I will try to keep it fun. Hopefully, I am a strong believer that learning and like this kind of like talking head situation needs to be fun. I'll try to do more things. I like video games, so we're in Twitch. So if you want me to play video games and talk about them through the lens of international law, let me know. I don't know. We This space is still being defined. Um, but anyway, before I start dealing with the opinion, um, I guess it's good to set up what happened, right? How we got into this situation of the advisory opinion. So first, let's start with um, what is an advisory opinion. So an advisory opinion is one of the two types of jurisdiction that the International Court of Justice has or possesses. The International Court of Justice being the highest judicial organ of the United Nations. It's let's say the UN's tribunal. It deals with all kinds of international law questions, so long as it has jurisdiction for it. Meaning that you need to like have agreed to the jurisdiction. International law is not like domestic law, where like if you run a red light, you can automatically end up with a fine and you need to go to a judge and appeal and all that. In international law, if you run an international law red light, you don't necessarily end up in a court because that court does not necessarily have jurisdiction. Right. So bear that in mind going forward. And within these two types, the contentious jurisdiction of the International Court of Justice is the one where like you have a dispute. You have two states that don't agree um, on two states that don't agree on the uh, interpretation of a treaty or how to apply international law, and they sign a compromise and they end up or sign a treaty and end up in the ICJ solving the dispute, right? The advisory jurisdiction, though, is when an organ of the United Nations doesn't know how to interpret a specific legal question which is within its own jurisdiction, within its own powers. So in this case, the United Nations General Assembly asked the International Court of Justice to um, let's say clarify how it should act when it comes to the illegality of Israel's occupation of the West Bank, East Jerusalem, and Gaza. Okay, so oh hi, accidental jurist. It's nice to see people from Twitter here. um, welcome. Um, and I like also that the chat room is like half English and then some a little Portuguese here and there. Um, Cassius Cleito is asking if they have. I'm going to translate to English because that's the language we're talking. I'm open to doing streams in other languages, español también. So I'm open to do them in Spanish and Portuguese if you want. We can do a redux of this and we can have like a conversation in Portuguese or in Spanish. That's not a problem. Um, but Cassius Cleito is asking if they have, if the ICJ has jurisdiction over the entire world or all the states that are in the UN, or whether you have to go into the UN and accept jurisdiction. Um, yeah, it is a UN organ, so you do need to be a member of the United Nations. That was part of why Palestine was not did not have access to it because it wasn't part of the like UN system. It was a non-state, let's say. So that is why the decision of the Palestinian Authority to engage with the concept of statehood and become an observer state at the UN and all of this is important because it gives it increased access into the world of the ICJ. Now remember, Palestine is not the member of this procedure or the procedure at the contentious procedure between South Africa and Israel. This case was brought by the General Assembly of the United Nations to ask how should we act with regards to this situation that's been ongoing for 75 years, right? So this is not about Palestine suing Israel. We're not there yet. We can talk about the probability of that later. Um, but let's just establish that right now what we are doing is we're talking about an advisory opinion by I have no idea what that little thing is. That like a is that the oh is that T? I get it. Okay, that's funny. Um, so we're dealing with an advisory opinion. Okay, so why is that important? Because you will see a lot of people that will tell you um, that it's just an advisory opinion, meaning that it's invalid, doesn't matter at all. Whatever was said is irrelevant. And I just want you to be able to have the tools to say, well, that's not really how it works. Okay. So, um, an advisory opinion is indeed advisory in the sense that it is not binding, meaning that whoever asks it does not need to comply with the order. It's not mandatory for it to comply with the order. It's just an advice so that they take it into account. But that advice is not it's not an opinion in the sense that it is this is what I think, but it doesn't really matter. It's just my opinion. No, it's an authoritative opinion, right? What is the difference between binding and authoritative? So uh, authoritative means that whatever they are saying reflects international law, is imbued with the authority of the tribunal at the highest level of the UN, right? So an advisory opinion is not binding in the sense that the UN does not need to comply with it in its entirety, but it does mean that whatever was said is international law, is interpreted by the highest tribunal possible, right? So don't confuse non-binding with non-authoritative. What the court has said is valid, it matters. It changes things. It changes how things work, right? Why? Because the law, as a concept, and this is my take on the law. Okay, as someone who studies the law for a living, um, how we approach the law, even how we tell first-year law students what the law is well, it's this system of rules that you know use. You grab from from the sky, and it's in the Middle Ages, they said that it was given to us by God, and it has these rules, and these rules are neutral because they are the law, right? This is the very liberal concept of law. And being neutral, you can use them as a third party to solve controversies between A and B. But I don't think that's how the law works at all. Um, and of course, here we get into a discussion about how to interpret the law, and we can do a conversation about that, but that would sidetrack me a little bit too much. So I'm going to stay on topic and say the law to me acts more like a discourse. The law is the law and therefore binding in a very big degree because you guys think it's binding. If I write in a piece of paper, everyone needs to subscribe to my channel. That's not binding. That's not law. But if everyone accepts that red means stop, then all of a sudden, yeah, there is some bindingness to it. So engaging with the law, discussing with the law, it matters to making the law binding. Okay, so when the court authoritatively says, this is what the law says, well, then in that case, then it's not just simply an opinion. It is the state of international law. Okay. How do I subscribe though? Like I said, this is Rosava Tolerance. I don't know how you subscribe. I'm probably the worst streamer ever right now. Um, I think you give follow, and then there's an option to subscribe once I achieve a certain number of followers. So I don't think I have that option yet. But like if you keep watching whatever I say, like probably I will be able to. Okay, let's see what questions you've been having here. It's a pot waving his. Oh, okay. So does that mean how should we act in accordance with international law? The silly serious asks. Well, silly serious, yes. So the advisory opinion essentially says this is what international law represents, says, that is the state of international law. So if you want to act in accordance with international law, then that means that you need to comply with that. And this is something that has popped up a lot in discussions about the opinion itself. We can get into that in further detail later, but the main reaction from the U.S. and Israel, and if you've been following me on Twitter, you'll see that I've been tracking all the reactions to the advisory opinion. One of the big reactions by them is to say, "Oh, this ruins the so-called negotiated position, right? The negotiated solution to the conflict. What we should do is get Palestine and Israel together and negotiate a solution." Um, and this opinion sort of like messes that up, right? I really disagree with that view because again, if this advisory opinion is authoritative, then it means that it is giving you the let's say the framework upon which your negotiations can operate. You cannot go into a negotiation and agree that something is illegal, right? If you sign a deal with someone to do something illegal, then that doesn't work. And in the case of this opinion, it's even worse because the court has said that the reason why the occupation is illegal is because it violates the right of Palestinians to self-determination, which is a jus cogens prohibition, meaning that you cannot agree that you will go against it. Like, for example, you cannot agree under international law that you will torture someone. That is not possible. It doesn't matter how much you say, oh, but I want you to torture me. That's still invalid because it goes against a jus cogens obligation, meaning a perentory norm that admits no contradiction, right? So the same goes for self-determination. And so you cannot really agree to a solution that is contrary to jus cogens, that is contrary to the rule against annexation, that is contrary to the rule against violating self-determination. You cannot do that. So if your negotiated solution is going to affect jus cogens norms and rules, then your negotiated solution is wrong, right? And you should do another one. So when you see that talking point of like, oh, you ruined the peace process. First of all, what peace process, right? But assuming that one would begin, this opinion, on the contrary, has clarified the the outlook for those negotiations and has told you what you can agree to and what you cannot. You cannot agree to something illegal. So, for example, the main idea here is that there's going to be land for peace, right? Israel is going to get land in exchange for. Sorry, Palestine is going to get land in exchange for peace, and so they're going to agree that certain settlements are going to be part of Israel because Israel needs to have its security interests addressed, right? And so, for example, the aerial settlement, one of the big settlements in Israel, is going to be part of Israel, so that Israel has strategic depth in its map, right? Um, you cannot do that in the sense that if you are saying that that settlement is an attempt at violating the prohibition on annexation, which is a Jus violation, um, then if you agree to formalize that, you are basically, um, you know, establishing something illegal as the status quo and making it permanent. That doesn't fly. So you would need to the way I interpret the opinion, of course, not the, other people will disagree. You would need to first end the occupation and then say, okay, this is the territory of the Palestinian state, this is the territory of the Israeli state, and they're going to exchange territory. Meaning that you're not going to make the occupation permanent, the settlements permanent. You're going to have something else. You're going to do a negotiation between equals, which is why, again, in my opinion, this this opinion changes things a lot because it allows us to change the dynamic of a negotiation that is premised on the idea that no, no, no. First, we negotiate, and the reward for negotiation is a Palestinian state as mandated by Israel. Right? I don't agree with that. This is the other way around. First, you have two states, then those states negotiate, right? And right now, I would argue you have two states. It's just that one of those states, Israel, doesn't recognize the other state, Palestine. And so I think we should change the chip and say first recognize the two states, then those two states negotiate, right? Um, okay, let me see what other. I had a list of questions prepared, but I don't think I'm going to need them because you guys are asking so many good questions here. Um, can the General Assembly do something of this opinion that the US cannot block? Oh, that's a very good question. So this is a question by Iconoclast 94. Thank you for that. Okay, so under the UN Charter, the judgments and decisions of the International Court of Justice can only be enforced at the UN Security Council level. And of course, since no one is actually bound to comply with this opinion, um, there is an argument to say, well, do we really need to even force someone to comply with something that they're not forced to comply with in the first place? So the enforcement mechanisms are weak already. They might be even weaker for advisory opinions, but there are ways to force the council to discuss the Security Council. Um, and of course, at the Security Council, as you probably know, the P5, the permanent five members, can veto that. So Russia, China, France, the UK, and the United States can veto any resolution, right? So they can veto a resolution of the UN Security Council saying, Israel, you need to comply with this decision. So that leaves the General Assembly. The General Assembly is usually mistaken for sort of like the parliament of of the world, which it isn't. It cannot issue binding rules. It only issues recommendations. There are some procedures within the UN to make uh, General Assembly resolutions more binding, especially when the Security Council is unable to come to a conclusion. But generally speaking, yeah, it's not easy to make to force the United States or Israel to do anything through a General Assembly resolution. So sadly, our enforcement mechanisms with this are limited. Do not despair, though. Yes, I don't know who said that. United for Peace, our Levant 17, United for Peace resolution. That's exactly what I'm talking about. When the Security Council is, if you've done Model UN, and I've done Model UN, a lot of Model UN, you will know Uniting for Peace resolution because it's the way that everyone gets away with all sorts of tricks and trying to make General Assembly resolutions binding. Um, but it's not as easy in the real world as it is in Model UN. Um, so yeah, our enforcement mechanisms are difficult, but I would encourage you to look at this case within a longer arc of history, because so not that long ago, Palestine didn't register at all. It wasn't a thing. It was a seat in the Arab League, like in 1949, after the creation of Israel. Um, Palestine was just a seat at the Arab League and nothing else, right? So now it is an observer state at the UN with probably the most amount of rights of any observer state ever, um, with cases at the ICC and ICJ, and that is recognized by the majority of the world. That took 75 years, right? And things are moving fast. I still remember when I was in college, when I was in law school in 2009. I wrote an article somewhere in Spanish-speaking, intranet, about the significance of Palestine acceding to the ICC. That was 2009. The ICC case that we're seeing now, that is like taking up to the point where there might be, probably will be, arrest warrants against Netanyahu soon. It took all those years, right? So things move slow, but they move. So don't despair at the fact that international law has limited enforceability problems, because it does change, and perhaps at this point in time, most importantly, it changes within a new way of understanding the world order. So world order is this set of rules that we have to understand how um, how global order functions, what states can do and cannot do, basically, or not just states, like any actor, right? And so um, I think at this stage, global order is shifting a lot. It's moving in a direction where, uh, when I was in law school, I went to law school between 2003 and 2010. States could not just sue Israel at the ICJ for genocide, or the UN General Assembly would not have asked for this advisory opinion. I remember when I was in law school, the big thing in accountability for international crimes was universal jurisdiction. This idea that you can prosecute anyone anywhere for specific crimes, like crimes against humanity, genocide, torture, etc. Right? Um, and so uh, Belgium had a very good, like super top notch law on universal jurisdiction. And they indicted Donald Rumsfeld, at the time Secretary of Defense of the United States, for war crimes in Iraq. And everyone was like, "Oh my God, what's going to happen?" I also remember Spain indicted 6 of the authors of the U.S. torture regime in Guantanamo, and everyone was like, "Oh my God, this is a new age for international law. This is amazing." Um, and uh, eventually, what happened is that the United States, like the Bush government, just picked up the phone and called Belgium and said, "Hey, Belgium, you know how you're the NATO headquarters?" Belgium was like, "Yeah, yeah, I love that." And the US was like, "Well, if you want to keep being the NATO headquarters, you will drop that case." And like that, every single universal jurisdiction law in the world, well, no, in the West, was watered down, right? Because you cannot go against that kind of power. Which is why nowadays, this is probably a discussion for another day, but like nowadays, universal jurisdiction is huge in the global south. Right now, Argentina, ironically, given the president that they have, but Argentina is now the center of universal jurisdiction claims. There are Myanmarese and Spanish international criminals, alleged international criminals, being prosecuted in Argentina. Right. So um, it's a very interesting story, the evolution of international criminal law, but let's leave that for another day. So in general, just don't despair. International law is a discipline that moves slowly, and I know we're in a state of urgency. I know we cannot really wait, but at the same time, it's important that we keep in mind that, like, this case wasn't even in response to October 7th. This case came about in early 2023, um, and it moved pretty quickly for international standards. Um, there's a great asymmetrical haircuts episode. Yeah, there is. I love asymmetrical haircuts. You should definitely follow them. Let me see if I can find another question here. Um, Win Game Dev says basically you can only comply with international law by complying with the advisory opinion. That would be my position. There are others that say that no, but my argument would be yes. You can only comply. So I don't want to be too realist. Like, legal realism is a discipline, is a philosophy that says that the law is whatever the judges say. So what is the law? Whatever the judge said. I don't subscribe to that. So I want to be careful when I say this. Okay, I don't think that just because a tribunal said something, it becomes good. Like, tribunals have legalized the most horrendous acts, the most immoral acts in the history of humanity. At one point, like, Jim Crow was legal, slavery was legal, and many courts said it's legal, it's legal, it's legal. So I don't want to come off as a legal realist. I am not a legal realist. I think the court has made many mistakes in the past. We can talk about that later. I don't think courts are perfect, but at the same time, given the system that we have, given that we want to preserve the integrity of the history of the system, states themselves cannot really pick and choose. Right? I can say I think this is wrong. We should change the president. We should, like, move around. Uh, we should assume the cost of disobeying this law. Right? For example, let's do some non-violent resistance to this unjust law. Perfect. But states themselves are sort of like more bound to this. So I would say, yeah, states cannot comply with international law without complying with this advisory opinion. That's the point of the advisory opinion. By that, I don't want you to go around saying, oh, courts have the final opinion on legal matters. Please don't do that, because then courts have said some pretty awful. Courts are saying some pretty awful things right now. Look at the United States Supreme Court, right? So be careful with that argument. But yes, in general, in the abstract, I would say this is a restatement of the state of international law as understood by the International Court of Justice, and to comply with it, states to comply with international law, states need to comply with this decision, with this opinion. There are situations where I would say that the right thing to do is to not comply with the judgment. Yes, absolutely. But if you want to comply with the law, then you need to comply with the judgment. I don't know if that's clear. Okay. What else? Uh, oh, okay. So there's someone asking here. Uh, do you think international law will be reworked, decolonized, as some say, after all this, given it feels too little too late for justice? This is by the Tricky Red. This is an amazing question. Thank you so much. I This could be an entire stream, okay, because I do work with, like, post-colonial analysis and, like, decolonial thought and all of that. I'm actually writing a paper on this right now, so it would be very interesting to discuss that paper with you guys. But so Audre Lorde's a legal thinker, philosopher, once said something that I really like. Oh, hola Colombia. um, I The master's tools will not bring down the master's house. Right? So it is very difficult to grab something that's embedded in the structure and use it to deconstruct the structure, not without some level of, like, strategic thinking. Right. So international law, and I might go on a tangent here. I apologize. International law is the product of colonialism. Like, why do we even have international law? There's a really good book, um, um, that talks about this. Um, I forgot the name right now. I'll think about it. I'll remember. Um, that talks about how the origin of international law is the colonial encounter between East and like, between the Western world and the indigenous world. That it is the first time when we started to think about the relationship between um, the West and another culture in terms of how do we deal with this other than through religion, because before that it was like, oh, the evil people and the good people, right? And when the Spanish get to the Americas, um the main way of thinking with this was like, we cannot say that the indigenous population of the Americas is evil because they never had access to, say, the Bible. So they did not reject the Bible. Yes, imperialism, sovereignty, and the making of international law. Thank you so much. I can't believe I forgot about that. Very good, very good. O negocio de Francisco de Vitoria. Yes, that's it's the affair of Francisco de Vitoria. Yes. Um, so when we go from this, going forward in time, what we call international law today did not come up until the 19th century. right? As a profession, as a people that actually become international lawyers, as opposed to like Francisco de Vitoria, who was a philosopher, or someone that dealt with theology, right? So in the 19th century, international law becomes a legal profession. And this is in Martti Koskaniemi is a very well-known scholar from Finland. He's amazing. You should read his book on the history of international law, The Gentle Civilizer of Nations. And so this professionalization of the discipline of international law um, came about because there was a factual need to organize this thing that we have established that's called the standard of civilization. Um, Meaning that the world was organized by Europeans in like very um, let's say hierarchical terms. There were civilized people, there were semi-civilized people, and there were savage people, right? So in this scenario, like you would organize the world, and people in like indigenous people would be savages, and then I don't know, Europeans that went to the colonies would be semi-civilized, like Latin Americans, for example, semi-civilized, like European descent Latin Americans, and then civilized people would be Westerners, right? And to organize how to distribute the world in these standards, rules were created, and those rules took the form of international law. So the Berlin conference that you know um, divided Africa among European countries, that was one of the first international law treaties of the professionalized era, right? So it is very difficult to deconstruct international law through international law. So will international law be deconstructed through an advisory opinion of the ICJ? Mm, I mean, not. A, I wouldn't hold my breath in that international law will protect itself a little bit, but it is a step in the right direction. I think decolonization will be a longer process that will require more than just a judgment. But it is a step in the right direction because, like I said in the beginning, it has changed the dynamics of how we conceive this conflict from one where you will Palestinians and Israel will negotiate. Notice how it's Palestinians; it's never Palestine. Palestinians and Israel will negotiate a solution, and as a reward for being good Palestinians and negotiating, they will get as a reward a state, not any kind of state, a demilitarized state without a right of return and with like security controlled by Israel. Right. So that sort of no longer works. This is why the U.S. and Israel are protesting this opinion, because now that is legalizing something that is illegal. So now you cannot do that, or you shouldn't be able to do that at least, right? So that's a step in the right direction. That's a step towards decolonization. The problem with trying to decolonize through law or through ICJ decisions is that at the end of the day, and again, we can do a video about this because this is a huge part of my research. At the end of the day, the very essence, the very concept of organizing the world in states and in nation states is flawed, right? It's like you can't have uh, societies that are built on the idea that there is one single nationality that is protected by the state. So the France for the French, Spain for the Spanish, and Peru for the Peruvians, right? That is a very big part of the problem of the coloniality of international law, because when you define a society that way, take for example the case of Peru, when you define that there is one single nation of Peruvians, in this case meaning Peruvians are, let's define it as Peruvians define it, the mixture of indigenous American people and um, European descendants. When you mix the two in Peru, you get Peruvians, right? And that means that whoever doesn't identify as part of that mix, anyone that identifies as specifically, indigenous, or people that have Japanese ancestry, or people that have other ancestries, they don't fit, and so they're excluded. So minorities, the concept of a minority to me is very colonial, and until we get rid of it, um, we won't be able to decolonize international law. So we won't accomplish that through a ICJ opinion, right? Okay, so I know. So I've answered 3 questions in 35 minutes, and you guys have like 7,000 questions in the comments. I am blown away by the reaction. If I don't answer your question, I'm very sure I'm not going to be able to answer them all. I think we're going to do this again, and I'm going to answer more questions. Okay. Let me see what else. Do you think other states will begin to offer uh, sanctions on Israel and end relations with them after this judgment? Okay, that's a good question. Um, from a perspective, my question, por favor. I will try. I will try to get to all of your questions. So, from the perspective of an anti-colonial international um, law, since we're talking about that, I would question the entire concept of the unilateral sanction. Okay, and I know we live in a real world where we need to do like where states sanction other states. Um, but let me can we watch this stream in replay? I'm trying. I don't know. My skills are very limited. I think I'm recording this, and if I am, then yes. Um, but I don't know if it'll work. So okay, sanctions. Thinking in terms of like what is the decolonial way of looking at this. The idea that you can sanction a state because they did something that you don't like is common and it's widespread, right? I understand that. But it is a tool that has been traditionally being used by the hegemonic powers against countries that are not hegemonic powers, so against usually global South states. So unilateral sanctions are usually condemned by global South states. Every year at I think it's the UN committee, the Human Rights Committee, the Human Rights Council, sorry, states get together and they approve a resolution led by global South states that say unilateral coercive measures are not good, right? So take that with a grain of salt as to how to approach the issue of sanctions. Okay, because it's different to have a unilateral sanction than to have a UN sanction, like a sanction by the UN Security Council or by an international organization. Um, but living in a world where there's a bunch of states that do think that they have a right to sanction other states, then I this decision specifically uh, doesn't mandate sanctions, but it certainly opens the door for them. Like if you want to be consistent in your application of international law, and that's a big if, then yes, you can sanction um, um, Israeli officials or Israel itself through this decision. Now, uh, there's reports now, for example, that Smotrich, the finance minister of Israel, that is in charge of colonizing the West Bank, will get sanctioned. He will be the first democratically elected sanctioned party by the U.S. in Israel. Right. So uh, that is a possibility. What the advisory opinion actually says is not so much sanction them, but like because this is a jus cogens violation, meaning that it violates a fundamental norm of international law that cannot be legal in any situation. Every state in the world has a duty to not recognize the effects of this situation. So one of the things that the court said is you cannot sign trade agreements with Israel. Now, if in those trade agreements Israel will consider products that come out of the West Bank as Israeli, and this is a huge topic for discussion because if you go to a supermarket and you live like probably in Europe or the United States, you might see uh, like products that say "Made in Israel." Not every country requires Israel to say that products coming from the West Bank and the settlements come from the West Bank and the settlements, right? So they will say that they come from Israel, and that helps Israel cement its control and annexation of the West Bank, right? The court is saying that is something that under international law you should not sign a treaty with Israel if in that treaty you help Israel annex the West Bank. And I saw a question over there somewhere like this is what the BDS movement has been saying. Yes, this is what the BDS movement has been saying. The BDS movement, of course, goes beyond that because it's not just applicable to states; it's applicable to people. Like we, as individuals, are asked to boycott. Um, so, more simply, arms embargo is clearly required. Yes, I would say that an arms embargo would be required at this point. I think it has been already for a while. In that. in my opinion, it is almost undeniable that Israeli targeting practices in Gaza and their support for settlers in the West Bank don't comply with international law. So I don't think we needed this opinion for that. I think that was already clear. But yeah, this opinion helps. Um, okay. Yes. I do think it's a good idea that like when I'm done with the question, if you want me to answer it, you just pop it back in, because like otherwise I won't see if I'm answering the question and it just falls through the chat. I might miss it. I'm really sorry. I'm really trying to answer as many as I can, but it's so many. Um, okay. Let me try and find the question. Uh, you're doing great. Thank you. I'm really trying. This is not really my forte. I'm not a I used to be a technology wizard, like when I was younger. Now I only use it to download video games and stuff like that. I'm not really that good with technology anymore. I'm millennials, and I'm like an old millennial. We are good with text. We're not good with What do you mean, ex geek? Geek right now, please. Um, Millennials are good with text. We're not good with image. Like Zoomers will call us on like a video call, and like we're like, no, I just want a regular phone call, please. Um, let's see. Questions. In your A lot of professional streamers have mods helping. I have one mod. um, Eventually this will grow. Um, let's see. Let me find another question. Uh, Anyone has a question that want me to answer? Because I'm having trouble finding them on the chat. It's your chance. The issue of Oslo. Okay, Oslo. So that is an interesting one. So, oh God. Okay, it's a long question. Um, let me get it to load. I have a question. We'll get to Judge Nolte in a second. Um, what is the legal status of Oslo and the PA? What should citizens do if they think their government is breaking into international law? Okay, let's get into Oslo. Oslo is the treaty through which the Palestinian Authority was created. It's a treaty between the PLO and Israel to like essentially do what we have now, which is instead of just having a political party, the PLO, um, leading Palestinian resistance against Israel, both peacefully and violently, um, they got together and recognized that the PLO would constitute a party within a Palestinian Authority that would act as a sort of government, right? Not really a government, but a sort of government. And there's a lot of discussion about whether Palestine should have agreed to us. Edward Said famously said it shouldn't, right? Um, and so because the argument was Noura Erakat has a fantastic book on Oslo. You should go read it. Arguing that Oslo, what it basically did was it cemented the occupation as the status quo that you cannot fight anymore. So like before that, you could resist occupation, but since Oslo, you've created this status quo where normality is occupation, when occupation cannot be normality, right? Occupation is violence. Occupation is like not a good thing, right? For Palestinians. And so in agreeing to sort of like regularize the occupation, yes, the Palestinians received institutionality through the Palestinian Authority, but at the same time they elevated the role of the occupation from a problem to the normality. This is why this case sort of is seen by the US and Israel as shifting the basis for negotiations. Because what this case has said is the normality has to go back to being a problem because it is illegal. All right. So there were a lot of people that were saying at the beginning of this like advisory opinion procedure that the court shouldn't say anything because you know Oslo exists. So everything should be done through Oslo. And what the advisory opinion says is, look, we're dealing with self-determination here. We're dealing with the prohibition of annexation here. You cannot possibly read Oslo as limiting those fundamental rights of Palestinians. So whatever Oslo did, it could not have limited the rights of Palestinians to self-determination, which is interesting, right? Because then that is the UK's argument in the ICC case. The UK recently filed an amicus brief, basically a brief telling the court the chamber what it thinks, saying that because Oslo exists, because Oslo is a thing, um, then Palestine does not have criminal jurisdiction over Palestinian land. And so it would not be able to delegate that criminal jurisdiction to the ICC. And therefore, you cannot really prosecute Israelis in Palestinian territory because there's no jurisdiction for the ICC because of Oslo. Because Oslo says that only Israel will be allowed to prosecute Israelis, and the Palestinian Authority does not have a, what do you call it, like a judicial system, right? So the UK is saying, since there's no judicial system because of Oslo, then Palestinians don't have a right to prosecute Israelis, therefore they cannot transfer that power to the ICC. Therefore, the prosecutor does not have that power in Palestine. And what the International Court of Justice, not the ICC, has said in this advisory opinion is that you cannot read Oslo in such a way. Because when you're dealing with Yuskogans, you're dealing with war crimes, you're dealing with crimes against humanity, you cannot possibly say that the parties at the Oslo Agreement agreed to not have, um, you know, uh, uh, um, prosecution for war crimes. That's not, you cannot possibly read Oslo that way. So the ICJ kind of like brought down the UK's argument at the ICC. Yeah, so that's basically the Oslo issue. Um, Accidental Jurist is saying that there will be domestic legal proceedings seeking to review government decisions to enter into trade agreements. Yes, definitely, there will be. There will be. I mean, there are right now in the UK. There are reports that there are. I live in the UK, of course. If you don't know that, if there are reports that people that arrive from Israel back into the UK are being asked questions about their role in the role in the IDF, right? Because I mean, at this point, it is so patent that they may have been complicit in war crimes that, yeah, it makes sense. You might see that developed slowly, of course, as the law develops, but you might see that developing. Thank you for following me, Mahu and TB. Okay, so Cassius Clayto is again saying, if I'm not mistaken, of uh, a group of people from the PLO left the PLO because of that. Not exactly because of that. That happened a little earlier. That was I don't remember the name, but it was the people that it was in the context of the Lebanon war. They separated from the PLO. They attacked the Israeli ambassador in London, and as a result, the Israel used that as an excuse to go into Lebanon in 1982, even though it hadn't been the PLO that did the attack. It had been like these people that separated. Um, let's see. Mm, This is because Professor Trakis says this is because international law must always be interpreted in such a way as to make the law actually work, right? Well, this is a broader point about the law. The law is conceived by lawyers as a system. It's supposed to make sense. So when you have two contradicting sets of laws, you're supposed to interpret them as if they make sense. And if they don't make sense, then you have other mechanisms to try to make them make sense. So yeah, you should try to read international law consistently. Um, so Donald M. Stats says, what should citizens do if they think their government is breaking international law? Well, I think the biggest thing you can do at this point as an individual, right? This is sort of like I don't use straws in restaurants because the sea turtles. And like, yeah, that's good. I mean, I don't use straws in restaurants because of the sea turtles. But at the same time, you're not fixing climate change through that, right? So your ability as an individual to affect structural issues is limited, right? So I would say the best thing you can do is demonstrate. If you can call a representative, call a representative. And I think those two things are important. Like in London, we have demonstrations every Saturday in favor of Palestine. So I think that's great. I think you should go to those demonstrations. Um, what else? What other questions do we have? Okay, unless anyone has any specific question, I have. There's a okay. Lant Ponce. This is in Spanish. Mexico shields himself in the fact that Israel is not subjected to any kind of sanction derived from the Security Council and therefore does not impose coercive measures. How is this advisory opinion? How can this advisory opinion help us to exercise pressure so that the government of Mexico imposes sanctions? Ooh, that's a tricky one because so Mexico has. Oh, Judge Nolte, I'll get to Judge Nolte. Remind me, okay? Mexico has a specific position with regards to the right to non-intervention because of its history. It's very big on. You can imagine a state that is bordering the United States has a lot of issues with protecting the right to non-interference in domestic affairs. Right, so there's a doctrine. It's a very strong doctrine in Mexico to defend non-intervention in domestic affairs. So Latin American states, not just Mexico, Latin American states in general don't impose sanctions. This was actually a very big point of discussion back when Venezuela started to commit crimes against humanity against demonstrators in 2014, because some states realized that under their domestic laws they could not actually impose unilateral sanctions because of this idea that usually what happens is that the United States sanctions um, Latin American states, and so we generally consider those illegal under international law. So it's not that Mexico is shielding itself on that. It's not. I don't feel that it's Israel specific. This is something that's very common in this discussion. Everyone thinks that everything is Israel specific when it isn't. So in this case, it's not really. I don't think it's related to Israel. I think it's related to a longer process of Latin American sense of non-intervention and defense of non-intervention. So I don't blame um, Mexico for that point of view. Judge Nolte. Judge Nolte is a very interesting one because Judge Nolte is the German judge, okay? And back in the genocide case, Judge Nolte was not very convinced of South Africa's argument that there was a genocide, and he wasn't very convinced because he thought that genocide. Um, uh, there's a way in which we interpret the crime of genocide. It's a way to interpret the crime of genocide that I disagree with, but it's what the court has said. Okay, um, again, going into this point of me not being a legal realist, the court has determined that for something to be genocide, it needs to be the only reasonable inference. Like the intent to destroy the population needs to be the only reasonable inference, right? And so, take for example the case of Latin American colonization. Was Spain committing a genocide, as like I believe, or was Spain trying to evangelize the indigenous population, and in the course of that committed a genocide without wanting to? So, under the understanding of the court, that is not a genocide because there's another reasonable inference that isn't intent to destroy. It's the evangelization of indigenous populations, which is, in my opinion, super messed up. Like I do not subscribe to this view. Okay, but it is what the court says. So Judge Nolte says, look, South Africa is going to need to argue that genocide and the intent to destroy is the only reasonable inference of what Israel is doing in Gaza. And I don't think, well, Judge Nolte said, I don't think that they can prove that because there's another reasonable inference, i.e., destroying Hamas. Right? So Israel would not really be committing a genocide. They would be committing a genocide as a result of that, right? As a result of trying to destroy Hamas. And therefore, it's not genocide, according to the view of Judge Nolte. Then something happened, something that probably Judge Nolte wasn't anticipating, which was the policy of starvation in Gaza. The policy of Israel of starving Gaza changed the dynamic a little bit because it's one thing to say that Israel is committing genocide because Israel is killing people in Gaza one by one, and then those killings amount to an intent to destroy, and it's another one to say 2.1 million people are starving. Right? Or have, like, I think the statistic is that 100% of Gaza has food insecurity and 20% are in like IPC level 5, right? So that's when Judge Nolte sort of like I call it the mild radicalization of Judge Nolte, where he joined the majority in the provisional measures decision on Rafah and said, okay, this is too much, right? This you cannot continue with this without endangering the rights of Palestinians. And this is where we got to this discussion of whether there was a plausible genocide or the right to not be subjected to genocide was plausible. Regardless of that discussion, um, IPC level 5 is the worst level of starvation. It's like when you are in extreme levels of hunger. Um, so Judge Nolte sort of like mildly changed his mind towards the okay, the starvation thing and the Rafah thing might be genocide, right? Um, but then we get to this advisory opinion, and Judge Nolte appended his own independent declaration where he explained why he thought that um, when the court said that Israel is violating Article 3 of CERT, meaning the Convention on the Elimination of All Forms of Racial Discrimination, that article bans two things. It bans racial segregation, say the United States in the 1940s, Jim Crow, and it bans apartheid, think South Africa. Okay. Judge Nolte said, I don't think when the court said that Israel is violating the Article 3 of the Third Convention, I don't think the court was saying that that amounted to apartheid. So it must mean only racial segregation. He's the only judge that framed it that way. Okay, why? Because he said apartheid, like genocide, has a specific intent. The specific intent is to establish a regime of racial domination of a racial minority. Right? To find that intent, you need uh, for that intent to be the only reasonable inference. So he genocided apartheid. Like he used the standard for genocide for apartheid, which is not something that we have said in the past. Like we international lawyers, like it's not like that. He didn't need to. He just did. Right. So um, his view is that this only reasonable inference standard needs to also apply to apartheid. And he says, I don't think that what Israel is doing in the West Bank is as the only reasonable inference apartheid. It could also be something else, like annexing the West Bank or like I don't know, whatever, right? So what this tells me is that Judge Nolte probably will not regulate, probably will not solve the case, adjudicate the case in South Africa in favor of South Africa because he's taking a very limited, interpretation of what this crime, of what the probationary standard and the evidence standard is. It might be that he's allowed to be swayed into the starvation argument as happened during the provisional measures thing. Uh, but it's difficult. I don't see Judge Nolte being radicalized enough to join the ranks of I don't know Judge Charlesworth, for example, right? Um, okay, there's a thanks Toby B, the 19th committee meeting of the third. I'll check that. I haven't read it. I haven't read it, so thanks. Um, so let me see what else. What other questions? Sure, no problem. Happy to answer. Um, how can such a view hold? Nothing would be genocide then. So Kaela Strass, sorry if I mispronounced your name. Yeah, I mean, I agree. I think this view sort of makes it very difficult to find genocide. I recently wrote a column in the Intercept Brazil. If you speak Portuguese, go to the Intercept and read my column there on this specifically. When this standard was passed, was approved in the case between Croatia and Serbia and Montenegro in 2015, I think. I might be getting the date wrong. Um, the Brazilian judge, Antonio Augusto Cansado Trindade, uh, who is like a giant of Latin American international law, and like we all hold him in great esteem. He passed away already, sadly. He said that this standard was um, a diktat that had no real grounding on the law. It was just an invention, and I agree with him. It's just a jurisprudential creation by the court that limits the findings of genocides. And this is a trend. Like many states have used this argument in the past. Like my own country, Peru. So Peru, as most countries in the Amazon basin, as of the 1920s, 1910s, discovered that there was rubber in trees in the Amazon, and so started to colonize the Amazon, and essentially committed a bunch of genocides. There's the Putumayo genocide, there's the Alto Juruap genocide, the Matse genocide, a bunch of genocides that Peru has committed. Okay, and all of these were excused as a well, but what we're really doing is we're bringing this indigenous population that's, think again in this standard of civilization that I mentioned before, that in the book of like Martikos Kanyemi's book, um, we're bringing these people that are in a lower scale of development, because when you say development, it's the language of development is sort of how the standard of civilization continues with us to our days. um, we're bringing them to a better state of development. We're acculturating them, integrating them into modern Western, life. And really, they were being genocided, right? So this idea that, oh, it wasn't genocide because I wasn't really trying to kill them, I was trying to develop them, or quote civilize them, it's an old excuse, and it's a pity to me that it's this is essentially that turned into law at the ICJ. I don't subscribe to it. I think we should do away with it, and I think Francesca Albanese, the special rapporteur for Palestine at the UN, um, makes good points on this, on how like we really need to reinterpret how we conceive genocide, because right now what we have is this idea that not everything can be genocide, because if everything is genocide, then nothing is genocide. And I think it works the other way around. Right now, the way that we understand this is nothing is genocide, period. And if nothing is genocide, then nothing is genocide. And that's just not true. Genocide is essential to the way the world order was created. I mean, there's people from all over the world in this chat. Think of your own country's histories. At some point, you will get to a genocide. Like it's very difficult. Yeah, in Brazil there was the integração, the aculturação policy was a genocide. I agree, Cassius. Um, and think of your countries. Like you can actually do this alphabetically. You can go like states with A, states with B, states with C. Like Argentina committed a genocide when it conquered the desert, quote unquote. Uh, the southern parts of Argentina were not colonized by the Spanish. So they went in there and they killed all the indigenous people that lived there. Brazil, the Amazon genocide, right? The acculturation genocide. Chile, also they pacified the Mapuche in the south, also not colonized by the Spanish. So they went in the 1800s and killed a bunch of Mapuches. Um, A, B, C, D. Denmark. Denmark had a lot of like family planning, quote unquote, family planning policies in Greenland that ended up preventing kids from being born. That's a genocide. Um, what country with an E? You can do this alphabetically. Every country in history has committed a genocide. So this idea that genocide is a crime of crimes that only happens once in a generation is a mistake. It's wrong, and we should fix it. Um, so hopefully my next paper is about this. So like hopefully that people will read it and like it. On this, there's a very good book by Dirk Moses called "The Problems of Genocide." I recommend you read it and take a look. It's really really good. Um, let's see what else. Mm, uh, Sebutinde's opinion. Okay, woof. Let me get ready. um, okay, so Sebutinde's opinion. So as you know, Judge Sebutinde is from Uganda, and she has been consistently ruling on the side of like the traditional Israeli position, right? Um, I think in this case in particular, it was interesting because the Israeli brief, if you read it, it's 5 pages long, because Israel did not want to just um, participate in this, give credence to this. Um, there are already influential voices within the Israeli and Jewish communities that are calling on Israel to like boycott the UN and like withdraw from the ICJ's jurisdiction and everything. So Israel just submitted 5 pages, but then Fiji, the state of Fiji in Polynesia, submitted a very detailed position, essentially repeating the arguments of Israel, which is quite remarkable, right? Because Fiji is not known for having like this super aggressive foreign policy. So, I mean, something happened behind closed doors, and they submitted this like very detailed position defending the Israeli position. And I think it's just resonated with Judge Sebutinde. Um, I don't agree with her views, of course. I think they are. I think this ends up leading me to like addressing the Israeli counterclaim of this opinion, because there's this idea at the heart of the Israeli position that so wants to see the world in this like there's two ways, right? On the one hand, it all started in October 7th, and on the second one, it actually didn't start on October 7th. It started 4,000 years into the past, right? When the Israelites existed in Judea, and then they draw a continuous line from that to the present, which is not that different from like what Peruvians do in the sense of like when we talk about the Incas and the Chimu and all of these like pre-Spanish civilizations in school, my teachers would talk about the ancient Peruvians. And I think that's absolutely fine if you want to draw a line to your ancestors and say like, yeah, we shared some commonalities. In the case of the Israelites and the Israelis, shared the same like religious views and the same kind of like historical connection to this specific land, which was in their religion granted to them by God. I think that's all okay. The problem for me is when you turn that into a sovereign argument, when you turn that into there's a direct line between this Iron Age civilization and my 21st century claim to sovereignty. I don't think that's how it works. Um, I don't think the ancient Peruvians gave Peruvians right over the land. So I struggle with that idea that there is some sort of like a Jewish sovereign claim, which brings me to like a separate conversation that we can have in a minute about like how Israel came to be. Um, but yeah, I think what Judge Sebutinde is doing is she's conflating this uh, in legal terms, and she's conflating this history into legal terms, and I just don't. I fundamentally disagree. We can talk more about the history of the conflict. Probably should leave that for a different stream because like we've already done an hour here, and I don't want to have to deal with the history of the Israeli-Palestinian conflict after speaking for an hour. um, Let me see if there's another question. Oh, okay. I like this one. The silly series again says like, what about the Jordanian annexation in 1948 of the West Bank? It was never recognized, therefore Israel is not occupying. Um, so this was something that popped up in the case because the advisory opinion only addresses the occupation from the moment it started, from the moment um, it arose in 1967 after the Six Day War. So it doesn't really go back to 1948, um, and it doesn't really argue about the occupation as such, but it rather argues about what Israeli practices have led to in that occupation. Right. So this is something that Judge Salam, president of the ICJ, mentioned in his opinion. He said, "What we have determined is that because Israeli practices and policies in the West Bank violate self-determination, because they violate the rule against annexation and because they systematically discriminate Palestinians, those practices and policies have made the occupation illegal. Because under international law, theoretically, occupation is just a matter of fact, something that happens in war. So it's not legal or illegal to occupy territory in war. It's just something that happens. There are exceptions in Latin America, for example. It is illegal to occupy territory because we have awesome treaties, but we can talk about that in another time. It's also illegal to have nuclear weapons in Latin America. We can talk about how awesome Latin American international law is in another time. But generally, yeah, it's not theoretically illegal to occupy territory in war. What the court said is the occupation has devolved into an illegal occupation because of Israeli practices and policies. But Judge Salam said, okay, but wait a minute. Why would we not look at to the occupation ab initio, as in from the beginning? We didn't need to, but if we were to look into the occupation ab initio, then you get into this argument, right? The Israeli argument is, who did we take the West Bank from? Who are we occupying it from? No one. As far as Israel is concerned, the West Bank is not occupied. This is what Sebutin this is in her opinion, right? The West Bank is disputed with the purported state of Palestine, but it is not occupied because there was no state from which we took it. The West Bank at the moment of 1967, at the moment of the war, the West Bank was like taken from Jordan, not from Palestine, right? And so you cannot occupy territory that doesn't belong to quote unquote anyone, right? And this is extremely problematic because first it ignores at least my position, that is that the Palestinian state exists for decades now. I don't understand why the mandate for Palestine would not have created a Palestinian state. We can talk about that later. But I think I know my position is minoritarian, but I think the Palestinian state was born in 1922, not in 1988. So I think at that point there already was a Palestinian state being occupied and everything. But if you don't agree with me, that territory is still not res nullius. It's not territorium nullius. It's not empty land that doesn't belong to anyone. It is a land where there is a people that have a sovereign right to that land. So you are taking it from them. So you are occupying it. But in any case, if you took it from Jordan, um, there's a peace treaty with Jordan, right? So you would be continuing that occupation beyond the peace treaty. And in no situation can an occupation be legal and in time of peace. If you have peace, then you cannot occupy land, right? That would be aggression. That would be the crime of aggression. So you would have, if you're occupying the West Bank after the end of the war with Jordan, then that's an act of aggression against the land, right? Because the war ended. Now, you can go even further back and say, did you even have a right to set up an occupation? Because yes, you can tell me that in the course of war, you can occupy, and that's a matter of fact thing. Yes, that is an argument from the point of view of the jus in bello. The jus in bello is the law that regulates war as you are conducting war. So, are you committing war crimes? Are you committing a violation of international humanitarian law? Yes. Under that law, the occupation per se is not legal or illegal, right? Because it just happens. It's not a war crime to occupy a country. But under the jus ad bellum, the law that decides whether you can go to war or not, then occupation becomes use of force. It doesn't become like an aspect of a regular activity in the war. It becomes a specific use of force, right? So, did Israel have a right to use force in the West Bank in 1967? And as we know, the Six-Day War was the result of a preemptive strike by Israel. Israel believed that it was going to be attacked. So instead of waiting until being attacked, they decided to attack first. And so by attacking first, before an imminent attack was underway, before you had Israel struck tanks in their warehouses and Egyptian planes in their warehouses, not like going to attack Israel. It wasn't it wasn't self-defense against an imminent attack. It was a preemptive attack before Jordan and Egypt attacked. Then that would have been an unlawful use of force, and therefore the occupation from the very beginning would be illegal. This was actually the Arab League's point in, if you remember that video that went viral with Ralph Wild talking about the occupation in this case. um, that was his argument, right? So the argument would be that the occupation itself was illegal from the very beginning, not just because it became illegal because of what Israel did as a result of the occupation, but that Israel never actually had the right to deploy force against this territory in the beginning. So this was a discussion that the court did not need to solve, so it didn't, but it did come up with, like, in Judge Salam's opinion. So there there are many of us who think that the occupation was actually never legal. Whereas this opinion only says that the occupation, we don't know if it was legal or not from the beginning. We know that it's become illegal now. So just so you know, that's the argument with the we're not really occupying anyone thing. Um, Accidental Jurist says occupation also does not depend on the territory being owned by anyone prior to the entry of a foreign military. It just has to be not owned by the state that is sending its military. Yeah, absolutely. Otherwise, like there's all sorts of funny borders in the world, right? So there's this area between Sudan and Egypt that is called Bir Tawil. Like if you ever wanted to set up your own country, you're sort of running out of space in the world to do it. But if you were to create one anywhere in the world, it would be there. So you have two colonial borders intersecting, and depending on which line you choose, Egypt or Sudan would have bigger access to the coast. So of course they each choose the other line, right? And because they intersect, there's a little piece of land in between Egypt and Sudan that's called Bir Tawil. Google it. Like go on like Google Maps and check it out. That little piece of land is not claimed by Sudan and is not claimed by Egypt. So theoretically, neither of them claims it. That doesn't mean that you know anyone can just go there and say, "So this is mine now," right? Because and claim that the people that live there, well, there's no one lives in Birtawil, but if people live there, the people there are now my people. Because that would be like that would not make sense. So yeah, you don't need to have the territory being owned by anyone for it to be occupied, right? Um, Let me see what else. City Serious, thank you. That was so helpful. Thank you for asking the question. Um, what should pro-Palestinian organizations be pushing for in terms of demands on our governments after the ICJ opinion? Yeah, I think canceling trade agreements that recognize the occupation is something that realistically can be asked. Arms embargo as well. Sanctions, I've already said that I don't really like sanctions, unilateral sanctions to begin with. But I think, I mean, if states sanction, then it sort of makes sense. Yeah. So yeah, these are all things that can be pushed for. Uh, yeah. Spelling the land between Egypt and Sudan. So that would be Bir Tawil. It's a B for Bravo, I for India, R for Romeo, space, T for I don't know military alphabet. T for I think it's Tom. T for Tango. Um, A for Alpha. W, I for India, and L for Lima. Do we expect more countries to recognize Palestine? Yes, I think you should be looking at a set of countries actually. I would be looking at Japan. It might be that Japan could be the next one. There's been some interesting declarations on that. Yeah, Birtawil, that's the right pronunciation, the right spelling. Um, I would look at Japan, and then it it is a I do think that more recognitions are going to come. It's going to take some time. France, that's tricky because it maybe, but I don't know if Macron is in a position to do that right now. I hope maybe. I don't. I wouldn't put all my eggs in that basket. My Okay, I'm gonna make a prediction. Okay, maybe I get it wrong, maybe I get it right, but I think the next state to recognize Palestine will be Japan. If I win, then I don't know. I win a smiley face on my forehead. Um, then what else? What are the questions? Mm, what difference will canceling trade agreements make if the U.S. doesn't acknowledge the ICJ opinion? Well, because it would be agreements by different states, right? Um, I think there's a solid economic argument here for canceling trade. I mean, sure, the United States won't do it, but other states might. The European Union might. Um, let's see what else. Um, Judge Tomka's decision to vote against the fact that Israel's presence in the OPT is unlawful and also end its presence ASAP, while at the same time voting 478 that states and organizations should not recognize the situation as legal. I'm having trouble remembering Judge Tomka's decision because like it's so many. There's so many declarations. Is that the one? I think he's the one that said that he thought that the occupation was illegal, but because of what Israel had said, but that doesn't mean that it is illegal per se. And so, if Israel stops doing what it is doing, then the occupation would go automatically go back to being like neutral. And so, this is where Judge Salam's opinion on whether the occupation is illegal ab initio matters, right? Because so what Tomka, I think it was Tomka, what Tomka was saying was. We are saying that the occupation is illegal because Israel is doing this, this, and this. So if Israel stops doing this, this, and this, then the occupation would go back to being a regular occupation. And Judge Salam would say, no, it wouldn't, because it's illegal from the very beginning. So Tomka said, I will not join the decision that says that the resolution that says that Israel needs to immediately finish and terminate it, or not immediately, as fast as possible, terminate its occupation, because I feel like this can still be salvaged. And so this also means that international organizations don't necessarily need to end ties with the occupation. They just need to end ties with the occupation as it is right now. I don't know if that answers the question. Academic boycott. Okay, so Landpons asks about academic boycott. So I have signed a statement on um, joining efforts to academically boycott institutions that contribute to the occupation. Okay, and it's important to understand what does the boycott means, because the BDS movement, it's usually misinterpreted. Like, it does not mean that you cannot work with with Israeli colleagues. Like, I have Israeli colleagues that I think are doing interesting work, and I think you should follow them. Um, and they're, they will be part of a solution going forward. It does mean that the institutions, the Israeli universities that operate in Israel, are inescapably tied to the occupation. They have campuses in the settlements. They do R&D for the IDF. They offer benefits for IDF soldiers. So those organizations should not be allowed to continue engaging with with Western universities, or any university that wants to boycott this illegal, unlawful presence in the West Bank, right? So I guess the important thing with the academic boycott is distinguish between the academic boycott. It's like the idea that you need to boycott the institutions and the structures that maintain the occupation, and then getting into the very murky land of, I'm gonna ban you. Like, I'm gonna ban this person individually because they are Israeli, no matter what they think, no matter what they do. I don't like that in general. I think that's been used against uh, like for example, people states saying that they will not grant visas to Russian nationals no matter what. And I mean, that's complicated, because you don't know what that person has done. Why do they need to emigrate from Russia, right? So I would not target individuals blanketly, like en masse, right? But I do think that institutional arrangements, like EU Horizon, for example, good one, Toby B, should be reevaluated. Yeah, institutional contacts. Like, if you ask me to join a research group with a university in Israel, for example, I would say no, thank you. Um, do you think one of the reasons U.S. is so against giving Palestinians the right of self-determination is because of its colonial past? For example, can the Native Americans declare their reservations an independent state and ask for reparations? Oh, this is a great question. I could do an entire stream about this, because this is a very common misconception. So in decolonial theory, um, what indigenous populations ask for, it actually resonates a lot with the plight of the Palestinians. And what you need to understand in terms of how to conceive decolonization is that indigeneity is a category that is like is subjected to coloniality, right? To this kind of relationship. This is a specific bond between the state or the entity that is acting in colonial ways and the people that are being treated colonially. This is let's say, let me put it this way. Just because a country decolonized doesn't mean it stopped being colonial. The United States decolonized, right? It's no longer a colony of the UK. It is still absolutely colonial. Um, and so acting acting colonially means putting yourself on top of someone else. Oppression, subjugation, racial ethnic subjugation. It means placing someone in this scale of civilization, right? Of like civilized, semi-civilized, and uncivilized, right? So decolonization does not simply mean reversing that, so that now we are greeted by our indigenous overlords, right? Um, I don't know of any indigenous movement that promotes that. That promotes like, oh, we want to be authoritarians now and like expel every person from every place on earth that once belonged to indigenous people. On the contrary, it's about decolonization is about disassembling structures. What structures? The hegemonic structures that have created the world we live in. Like, for example, the idea of the nation state, where indigenous people are minorities in a society that is built by one specific nation. France for the French, Germany for the Germans, Peru for the Peruvians, and the Quechua people and the Aymara people of Peru are minorities in Peru because they don't conform to this idea of the nation as the union of indigenous and Spanish. They are actually only indigenous and therefore don't conform. And so if they are sitting on top of valuable resources, the right thing to do, quote unquote, the right thing to do, of course, it's super wrong, but like the right thing to do is to remove them so that the nation can access this these resources unimpeded. All right, so they are an obstacle to the development of the nation. There's a great article in Spanish. I forget the name of the author, but it's a obstáculos al progreso, which is about indigeneity. I might suggest it on Twitter later. Um, and so no one is arguing within the indigenous movement, not that I know at least, that the right thing to do is to then impose colonialism on, the Republican state. So take, for example, Fausto Reynaga. Fausto Reynaga is an Aymara revolutionary thinker from Bolivia. And what he argues is that Bolivia is essentially two states. An indigenous state, which he calls the República India, the Indian Republic, and a Western state led by, the descendants of Europeans. And the Western state has sort of like forever oppressed the indigenous states. And so these two states don't live in equal status. His proposal for disassembling this structure of the idea that Western society is superior to indigenous society is to disassemble the idea of a single nation state, that the Bolivian nation is this Western nation and the indigenous people are minorities in their own countries, and rather creating a plurinational country. Well, he doesn't use the word plurinationalism, but it's how it's evolved. The term has evolved into that, and create a country where we recognize that the concept of nationhood is complex. The Bolivian nation can be composed of indigenous people and Western people and like and mixed miscegenated people, and everyone in that society should have a right to self-determination, as opposed to right now, where indigenous people don't have a right to self-determination, and the Western Republic oppresses them and displaces them to get natural resources that are underneath their communities. Right. So it's about disassembling, not getting revenge. Right. So um, my my view of this is like the decolonization of Bolivia, of Peru, of anywhere in the world goes through what in the Israeli-Palestinian context we sometimes is referred to as the one state solution. Like one state that recognizes that in that state there are more than one nation, Palestinians and Israelis, and like Bedouins and all other like nations that you can find inside of Israel. And instead of needing to split them up because you need to have like this Jewish state and this Arab state, and they need to be like ethno states, you would just have a country where everyone recognizes that uh, Jewish people have rights and Palestinian people have rights, and it can still be the national home of Jewish people, the national home of Palestinian people, and still be a democratic state that is not bound by this ethno-nationalist ethos. Sort of like what Belgium has right now. If anyone here is from Belgium, Belgium is the national home of Walloons and Flemish people. And they don't need to create Flanders and they don't need to create Wallonia to recognize that these people have rights that need to be protected at the collective and the individual level, right? So uh, um, that's sort of like what decolonization would say. So if the United States is thinking, oh my God, if I recognize Palestinian state, and I don't know if this is true, but if it's thinking, if I recognize Palestinian rights, then the indigenous people in the United States will claim to have like states of their own. I think that would be very misguided and very ignorant of the current trends on the decolonization theory. What is UNPO? Is this like Alonso buying a pin of UNPO to do live on decolonialism? Let me know. Um, no, Toby B says Northern Ireland Good Friday peace agreement operated by basically breaking this nation state norm and creating a joint identity in Northern Ireland. Absolutely. Northern Ireland is an excellent example of the kind of decolonization that I'm talking about. The problem with coloniality is this idea that the world is a map where you draw lines and you say, this is mine, this is yours. This is Jewish, this is not Jewish. The lesson from Northern Ireland is, hey, if you remove the line, you can think whatever you want about the line. You can think that whatever you want about it. Um, we will have peace instead. Who cares about the line is the lesson from Northern Ireland. And it worked. It solved the conflict. So of course it's not my place to tell indigenous people to tell Israelis and Palestinians how to solve their own conflict. So I will not purport to be doing that. Um, I don't want to do that. I think it's for Israelis and Palestinians to solve their own conflict. But if they ever asked me what the best solution for the Israeli-Palestinian conflict is, I would say the same solution for any country that needs to decolonize its complex concept of nationality. I would apply the same solution to Bolivia and Peru as I would apply to Israel, which is this argument that it's always about Israel. It's not. I'm applying the same theories that I apply to my own country to Israel, and recommend a decolonized one-state solution where everyone has like equal rights to self-determination. That would be my proposal. It's not my place, but that would be my proposal. Um, UNPO, unrepresented nations and people. Oh yeah, yeah. Okay, sorry. Um, um, sure. We can do a stream about decolonization and decolonial theories. That would be really cool. If you'd like that, let me know. Um, okay, we are at 1 hour and 40 minutes. Is there anyone that really would like a question answered before I start to wrap this up? I have a question concerning settlers. Since settlements are considered war crimes under international law, are settlers war criminals themselves? And since settlements don't have legal status, can they be legally brought down using force, similar to as court has declared that walls should be brought down by force? Okay, this is a tricky question, okay, because the the building of the settlement is attributed to the state. So the state is committing the war crime by transferring people into the settlement. So theoretically, when you transfer people, you are not necessarily saying that those people that are being transferred are committing the war crime itself. The thing about the settlements in Israel is that this is not just a state initiative. Many of these settlers themselves participate and enable through regular commercial activities. You've seen what they do in like in churches in Canada, like churches like synagogues in Canada, selling Palestinian land in settlements. Um, so you could argue that some of these settlers are actually aiding and abetting in the commission of war crimes. So it's not that by the very fact of living in a settlement, you necessarily are a war criminal. It just means that if you are aiding and abetting the commission of the state's war crime, then you are committing a war crime as an aid as an accomplice. So it's a little bit trickier than that. Okay. Can you expand on the one-state solution? You only ever hear the novel idea of a two-state solution in the Western media. Can you tell us why you don't think this would work? So okay, I'm getting into very tricky, murky territory here, and I would need more time to explain it. And so I will probably leave this for another stream. But let me just say in broad brushes what I think is the problem with the two-state solution. The problem with the two-state solution is that it is still a solution based on the idea of the state, right? So um, what is my solution to solve the Peruvian situation, meaning the problem wherein in Peru there is a society, a part of the society that is indigenous, that is not really treated equally as, say, the Western descendant society, you know, or the mestizo population. Like, what is my solution for this? I would argue that we need to deconstruct the idea of Peru as as a Western republic with a Western concept of nation, and you know and indigenous minorities. I think the minority issue is the problem. So I would propose for Peru sort of like a one-state solution for Peru, whereas now we have two nations, two separate sections of society. I would join them. I would give indigenous peoples representation in Congress. I would like make sure that there are protections for national rights, for like national languages. Like Quechua should be an official language in Peru. I think indigenous land should be protected from being like bought up and distributed among corporations. All of these things I would do to protect the idea of the Peruvian nation as plurinational, as not just Peru for the Peruvians, but Peru for the Peruvians and the Quechuas and the Aymaras and the Westerners and everyone, like the Criollos and everyone, right? So I would say that's the same problem the same problem that I find with the current notion of state in Peru is the same problem with the two-state solution. We will not necessarily get a Palestinian state that is independent and fully sovereign from the framework of a negotiation where the colonial arrangements that gave birth to this problem in the first place are not disassembled. Israel has already announced, if you read the latest uh, Donald Trump solution for the Middle East, if you read that, you will see that what is proposed as a Palestinian state is not really a state. It's another type, as another Oslo, another normalization of the status quo. Right? So that to me that is problematic. That won't solve the problem. It will place Palestine under the control of Israel again in different ways, and that's not self-determination. The only way to achieve self-determination is if we acknowledge that Palestinians have a right to self-determination, and I don't think the current idea of the state does that because it still acts under the perspective that Israel needs to be a Jewish state and Palestine needs to be an Arab Muslim state, and this idea of the ethno states will continue to create problems because you cannot just expel people that aren't Jewish from Israel. And like, I don't understand how this would work with the right of return and everything. You just can't. So, of course, if you need to maintain a ethno state, a duality of ethno states, then you will never achieve that kind of like coexistence that would come about from decolonization because you would still be functioning in terms of states. And I think that is the problem. The main problem with international law right now is the conception of the state as a Westphalian nation state. I don't know if that answers the question. I can do a better job with more time. But in short, my problem is yes, my problem is exactly what the tricky red is saying. Borders are violent, so the less borders, the better. Um, okay. Um, So, okay, guys, it's an hour and 45 minutes in. I'm going to start to wrap this up. I will do another one relatively soon because I can see that you guys had a lot of questions. And also let me know what else would you like to do here. Like, I mean, this is a completely informal space. I have no plans. Like I said in the beginning, I play video games. So if you would like to see me play a video game and talk about why that video game is like, violating international law or something, let me know and I'll do that. Um, or if you want a specific topic, if you would like to talk about decolonization next, I'm happy to do that as well. So just let me know either here or on Twitter, and we can have this like in a regular basis. I'm really happy that you found this informative and fun. The gaming is a plus. Yeah, awesome. Committing war crimes with Alonso next. um, I mean, sure. um, okay. So I'm very excited. I'm really happy that you guys found value in this. I am gonna start to wrap up this. If I didn't answer your questions, please like write them down and like save them for another time. I will probably do another one of these Q&As about the opinion because I know that there's a lot of interest still. And then we can discuss decolonization. We can discuss the history of the Israeli-Palestinian conflict. We can be creative. This is a space for you guys. Like I said in the beginning, the objective here is to get me out of that ivory tower where I'm isolated from everyone and like everyday arguments and get closer to you guys. Okay. Um, Thank you so much. I'll leave this on for a bit if you want to discuss in the chat room. I'll leave it in with like for 5 minutes with an end screen, and then I'll just finish the stream. Um, thank you so much. If you can subscribe to my channel, that would be great because then it can grow more. And I think I get perks and I like perks. So anyway, thank you so much. Muchas gracias. Muito obrigado. Oh, and we can make other language streams as well. See you next time. This was really great for me, and I hope it was great for you guys. Bye.